This is part 5 of contracts. You have an express contract. An express contract is a contract formed by words that express intent of the parties. This can be orally or written. Implied in fact contract is conduct that indicates assent or agreement of the parties. Quasi-contract is not really a contract per se. It's implied in law. This is generally an action that prevents unjust enrichment, such as a benefit has been conferred upon the defendant and plaintiff was acting without the intent to give a service or to intent to give for free, as a reasonable expectation of compensation, and it would be unfair to allow the defendant to retain that benefit. Looking at warranties, you have an express warranty. An express warranty is a promise, an affirmation, a description, a sample that is a basis of a bargain. Now, an express warranty is not formed by the seller giving an opinion. Where a sample is provided in a sale of goods, the goods must be like the sample. Now, disclaimers in the context of express warranty that conflict with the express warranty are ignored. An implied warranty of merchantability. These are where goods are warranted as fit for their ordinary purpose or as would pass without objection in the trade. Here the seller must be a merchant. The implied warranty of merchantability can be disclaimed with language, quote, as is. It may be given orally or in writing, but must use the term, quote, merchantability, end quote, and if in writing must be conspicuous, meaning obvious and not hidden. You have the implied warranty of fitness for a particular purpose. This is a warranty that the goods are fit for a particular purpose. This is formed where the seller has reason to know the buyer has a particular use for the goods, and the buyer is relying on seller's skill to select the goods. Here, the seller need not be a merchant. The warranty of fitness for a particular purpose may be disclaimed with, quote, as is, but it must be in writing and must be conspicuous. Looking at discharge of a contract or discharge of a duty to perform. Duty to perform is dismissed or discharged if performance becomes illegal or subject matter of the contract is destroyed, or in a personal services contract, the performing party dies and or becomes incapacitated, or generally where performance is impracticable. Now, looking at discharge for impracticability, this is where an unforeseeable event, the non-occurrence of which was a basic assumption, and the party seeking discharge is not at fault for the occurrence of the event. Now, if a party assumes risk of the event happening, then impracticability will not apply. This mirrors frustration of purpose, but under frustration of purpose, the event need not be completely unforeseeable. So impracticability would be painting a house, contracting for painting a house, and a landslide washes the house away. You can't be held to the contract or pay the painter. Third-party beneficiary contracts. We are only going to look at here the language under the second restatement of torts. Now, if no law is cited on the exam, you should use this language. This is where it is an intended and incidental beneficiary. So you have an intended beneficiary and an incidental beneficiary. First restatement of torts uses creditor and donee beneficiary. Second restatements uses intended and incidental beneficiaries, and you on the exam use that if no other law cited. An intended beneficiary, an example would be A agrees to paint B's house in return for B's promise to pay money to C, obviously because A owes C money. Here, C is an intended beneficiary. It is the intent of A and B that C should benefit from their agreement. Now here, C can recover money from B. C's rights vest with detrimental reliance on the agreement between A and B, a manifestation of assent to be paid through the agreement between A and B, or where C files a lawsuit. That's an intended beneficiary. An incidental beneficiary, an example would be A promises to buy B a car manufactured by C. Here, C is an incidental beneficiary of the agreement between A and B and has no rights. Looking at assignment of rights and delegation of duties, an assignment is a transfer of rights. A delegation is a transfer of duties. Looking at assignments, almost all rights can be assigned, even if disallowed by the contract. However, if disallowed by the contract, the assignment then operates as a breach of contract. Now, assignment is not allowed only when the assignment materially increases the duty and or risk of the obligor, the person bound to perform, or materially reduces obligor's chance of obtaining performance. And in an assignment, the assignee takes all rights and defenses of and or against the assignor. Looking at delegation, again, delegation is a transfer of duties. Assignment, rights, delegation, duty. Generally, all contract obligations can be delegated, except when a party has a substantial right in having the other party perform, or the contract specifically or expressly prohibits delegation. Now, a delegator is not released from liability. So if the delegatee does not perform, the delegator may still be liable to the party to whom the contract is supposed to benefit, or the duty is owed. Now, delegation in the contract for sales of goods is reasonable grounds for insecurity, and a party may demand assurances. And that completes Part 5 of contracts.